Welcome to English Practice and Podcasts. Anna and Mark here.
Hello, everyone.
Today we have some, frankly, pretty bad news for the large immigrant community.
Yeah, this is a major development.
It's especially tough for new immigrants from 75 countries around the world who are in the process of preparing for immigration to the United States.
People who've been waiting for years in many cases.
Exactly. Today, January 14, 2026, reports emerged, and these are citing a U.S. State Department memorandum that the United States is suspending the issuance of immigration visas to citizens of 75 countries.
And to be clear, suspending means a full stop. This means that new immigration visas will not be issued until further notice.
That is a tremendous amount of information, and I mean, even more stress being dropped onto millions of people globally.
Yep.
Okay, let's unpack this immediately.
We have to.
Because the scope of this halt is massive.
Yeah?
Yet we need to be very precise about the specific action being taken. The key date is just 1 week away. The restriction, according to the sources we have, is effective January 24, 2026, and it is strictly targeted at immigrant visas.
And that specificity is absolutely vital here. We're dealing with a surgical suspension, even though its geographic reach is global.
So what exactly is an immigrant visa for people who might not know the distinction?
An immigrant visa, for our listeners, is the visa intended for permanent residency.
The green card.
That's the one. The path to getting a green card, the long-term foundational status for living and working in the U.S.
So this is not a halt on tourism or temporary work.
No, but it's a complete freeze on the long-term permanent aspirations of millions.
And the timeline is what truly elevates this from a bureaucratic hurdle to a major policy crisis. The measure is set for an indefinite period.
That term, indefinite, holds immense weight.
It's not 6 months. It's not a year.
No.
Yeah.
It's indefinitely suspended until the State Department can revise its vetting procedures.
So indefinite means the process just stops until the executive branch decides its new rules are sufficient.
That's it. And when you look at the global reach, 75 different nations spanning every major continent, it's an unprecedented administrative action in the modern era of legal immigration.
It signals a tectonic shift, really.
A huge one. A shift in how the U.S. views who is worthy of permanent entry.
Before we get into the implications, let's dig into the why.
The official rationale.
Exactly. Because the administration has been very clear about the official justification for this radical step.
Mm-hmm.
It's not framed publicly as a security measure, is it?
Officially, no. The U.S. administration's primary objective and justification, based on the State Department memorandum cited in the sources, is centered entirely on the avoidance of public charge.
Public charge. Okay, so this is an economic framework, not a security one.
Exactly. They are using a legal concept that's been around since, I think, the 1880s, but applying it with a brand new, unprecedented rigor.
Okay, let's establish the core meaning of public charge. For decades, this referred to a person likely to become primarily dependent on the government for subsistence, right?
Yes, usually through cash assistance or, say, long-term institutionalized care.
But the administration asserts that based on historical data, and this is a critical point, data which has not been made public in any detailed way.
Right, we haven't seen the numbers.
That migrants from these specific 75 nations have historically used social welfare benefits at rates deemed too high.
Or potentially unsustainable by the current government standards.
That is the crucial political framing here. It sounds like this action is being entirely justified as a move to, quote, protect the welfare of American taxpayers.
And that framing is very strategic. They are positioning this as a fiscal responsibility measure.
So the argument is that the suspension is necessary.
The argument is that it's necessary to implement stricter vetting procedures. Procedures designed to prevent the entry of individuals who the government estimates. And estimation is key because they are judging future likelihood.
Right, it's a projection.
It's a projection of who may require government assistance or social help in the future. The entire system for these nations is being paused, so the screening criteria for financial self-sufficiency can be completely rewritten.
So if the State Department is implementing a pause to rewrite the rules, they are essentially acknowledging that the existing financial criteria, the current affidavit of support standards, for example.
That they're insufficient.
That they're insufficient for this specific population.
That is the implicit message, yes. And this is not happening in a vacuum. It's vital to connect this specific 75-nation economic suspension to the broader policy shifts we've seen.
Right. This follows a series of tightenings in immigration policy that began in late 2025.
Exactly. And while the official reason for the immigrant visa ban is purely tied to economic self-sufficiency, the broader context of tightening rules across the board, that does involve measures driven by underlying security considerations.
Okay, so even though the administration isn't publicly saying this is a security ban, the overarching atmosphere of scrutiny and tightening processes, which affects non-immigrant visas, and we'll get to that later, that has definitely been influenced by security concerns. They're just using the most potent legal tool they have, this public charge rule, to achieve a dramatic administrative halt.
Precisely. The public charge rule is the hammer they chose for the immigrant visa freeze because it is politically defensible as protecting taxpayers.
But when you look at the 75 nations selected,
That's where the questions begin.
why these 75?
Exactly. The lack of publicly released economic data linking high public charge use specifically to this exact list of countries suggests there may be other administrative priorities at play.
So there's a tension we need to hold in mind.
A huge tension between the official economic rationale and the vast, geographically diverse list of countries.
That geographic diversity is what we need to focus on next. I mean, the list itself is the source of great controversy and shock. We have to acknowledge the scale of this.
Staggering.
And let me just reiterate that the full official list has not yet been published for the general public.
This is coming from leaks from media reports.
Correct. The list we are discussing comes from media reports that have cited internal State Department memos. This is the list that is currently paralyzing consulate offices globally. And it's important for our listeners to hear the full roster. I will read it clearly now. Afghanistan, Albania, Algeria, Antigua and Barbuda, Armenia, Azerbaijan, Bahamas, Bangladesh, Barbados, Belarus, Belize, Bhutan, Bosnia, Brazil, Burma, which is Myanmar, Cambodia, Cameroon, Cabo Verde, Colombia, Cote d'Ivoire, Cuba, Democratic Republic of the Congo, Dominica, Egypt, Eritrea, Ethiopia, Fiji, Gambia, Georgia, Ghana, Grenada, Guatemala, Guinea, Iran, Iraq, Jamaica, Jordan, Kazakhstan, Kosovo, Kuwait, Kyrgyzstan, Laos, Lebanon, Liberia, Libya, Macedonia, Moldova, Mongolia, Montenegro, Morocco, Nepal, Nicaragua, Nigeria, Pakistan, Republic of the Congo, Russia, Rwanda, St. Kitts and Nevis, St. Lucia, St. Vincent and the Grenadines, Senegal, Sierra Leone, Somalia, South Sudan, Syria, Tanzania, Thailand, Togo, Tunisia, Uganda, Uruguay, Uzbekistan, and Yemen.
Wow.
It's a long list.
Thank you for reading that. Hearing that list back to back really gives you a sense of the sheer administrative chaos this is creating.
A logistical nightmare.
Logistical nightmare for the State Department itself, and I mean a catastrophic pause for the people involved. What stands out when you look at that list is the stunning lack of coherent geographical or economic logic.
Right.
We're not talking about a regional conflict zone ban, nor are we talking solely about low-income countries.
That's where the challenge to the official rationale begins, isn't it?
Absolutely.
You have nations from the former Soviet bloc like Russia, Belarus, and Moldova sitting alongside Western allies and, economically stable nations like Brazil, Kuwait, and Uruguay.
Exactly. Let's just break down the geographic patterns that the State Department has targeted here. In Europe, we see nations like Albania, Bosnia, and Montenegro, which have complex histories, but also Russia and Belarus, which carry heavy geopolitical weight.
Which suggests a blend of concerns.
It suggests a blend of security concerns bundled under this economic umbrella.
And moving to Asia and the Middle East.
Well, the inclusion of Afghanistan, Iraq, Iran, and Syria is perhaps unsurprising given the security environment. But then you also have nations like Thailand, Mongolia, and the Central Asian republics like Uzbekistan and Kazakhstan. It covers everything from democratic allies to states under heavy sanctions.
And the impact on the massive populations of Africa and Latin America is equally profound.
Absolutely. The African continent is heavily represented, with Nigeria, Egypt, Cameroon, Ghana, and many others included.
These are countries with some of the largest, most vibrant, and established diaspora communities in the United States.
They are. And the same goes for Latin America and the Caribbean, with major immigration source countries like Brazil, Colombia, Cuba, and Jamaica now facing this indefinite suspension.
So the policy is essentially asserting that a systemic pattern of potential public charge vulnerability exists across all 75 of these nations.
Right, regardless of whether they are a petrostate in the Gulf like Kuwait, a major trading partner like Brazil, or a developing democracy in Africa like Ghana.
And this wide net is precisely what human rights organizations will seize upon in potential legal challenges.
Without a doubt. They'll under that the selection is arbitrary and capricious.
Which highlights the tension, right? If the true goal were purely to prevent the utilization of social benefits, wouldn't the policy be based purely on an individual applicant's finances and not their country of origin?
That's the core tension. Previous public charge rules, even the controversial 2019 expansion, focused on the individual's projected use of benefits, regardless of nationality.
But this is different.
This 2026 suspension is an administrative shortcut. Instead of scrutinizing individuals from 195 countries, they halt 75, assuming that nationality is a sufficiently reliable proxy for future financial risk. It's an unprecedented step that treats country of origin as a risk factor for economic reliance.
Okay, let's talk brass tacks.
Let's.
What does this mean for the applicants who are currently in the queue, who have sold possessions, quit jobs, and are waiting for that final interview? We need to look at the impact on the specific visa categories.
For citizens of these 75 nations who are currently in the process of obtaining an immigrant visa, the sources are definitive. Expect a complete freeze of the process after the January 21st deadline.
Everything just stops.
Everything stops. This means consular interviews are canceled. Documents like medical exams, which often expire within 6 months, will go stale.
Oh, that's a huge problem.
It is. And petitions requiring consular processing are placed in limbo. The clock doesn't just stop, the momentum is destroyed, and the financial losses mount for the applicants.
The family reunification category, the Form I-130 petition for alien relative, is the bedrock of U.S. legal immigration. This is how U.S. citizens bring over spouses, children, parents. How hard is this pathway hit?
It's hit perhaps the hardest and most tragically.
Because it's American citizens who are waiting.
Exactly. The people waiting are often the closest family members of American citizens. The halt directly impacts all family reunification categories. The suspension is defined as an indefinite pause while selection criteria are revised.
And we're talking about people who might have been waiting 5, 10, even 20 years for their priority dates to become current.
Yes.
Now they are frozen, regardless of how long they've already waited.
Yeah. Exactly. And the sources make it clear that the eventual consequence, once processing resumes, will be that family members seeking to immigrate will be subject to vastly stricter screening to ensure they do not become a public charge.
So the rules for the affidavit of support will change dramatically.
They will have to.
Let's delve into that for a second. The affidavit of support, Form I-864. This is the critical document where the U.S. sponsor the relative promises to financially support the immigrant. What's the standard now, and what might a new, stricter standard look like?
Currently, the sponsor must demonstrate income at least 125% of the federal poverty guidelines.
Okay.
For family of 4, that currently puts the income requirement somewhere around $37,500. It's an achievable hurdle for many working-class American families.
But based on the administration's stated intent to prevent any perceived risk of future public charge.
The sources predict that the State Department will revise this requirement significantly. We could see the threshold jump to 150%, 200%, or even 250% of the poverty guidelines for sponsors of applicants from these 75 countries.
So an American citizen who earns, say, $40,000 a year may now find that even if their petition is eventually unfrozen, they are now financially ineligible to sponsor their parent or sibling.
Yes, simply because the government has raised the required income standard 3 or 4 times over.
Doesn't that effectively dismantle family reunification for the American middle class when it comes to these 75 countries?
That is the fear, and it is a very realistic one. By dramatically increasing the financial burden on the U.S. citizen sponsor, the administration effectively screens out lower and middle-income American families from exercising their right to reunite with relatives.
It turns the family-based system into a wealth-based system.
For this specific list of countries, yes.
Okay, let's shift to the Diversity Visa Lottery, the DV program. This offers a chance at permanent residency to people from countries with historically low rates of immigration to the U.S. We know the DV 2026 winners have already been selected.
They have.
Are they caught up in this freeze? And how does this affect someone who may have already spent thousands preparing?
The freeze explicitly includes the green card lottery. This is, I think, perhaps the cruelest aspect of the policy.
Why is that?
Because the DV lottery is a pathway specifically designed to provide opportunities to people who may not have immediate family ties or job offers in the U.S.
So for many, it's their only shot.
It's their only shot. And even if a winner has already been selected for the 2026 program, their case will be placed on hold indefinitely starting January 21st, 2026. Because the lottery is an immigrant visa pathway, It falls under the blanket suspension.
So you can just imagine someone in, say, Moldova who won the lottery, quit her job, maybe sold some property to cover the fees,
All the required medical exams and legal fees.
only to see her number come up for the final processing date, and now it's just indefinitely paused.
That is the reality facing thousands of people. And they are not only frozen, but their eligibility is time-sensitive. The diversity visa program is annual.
So there's a deadline.
There's a hard deadline. If processing is delayed past the end of the fiscal year, September 30th, 2026, they risk losing their selection entirely, especially if judicial challenges or procedural changes don't happen quickly.
So the suspension isn't just a pause for them. It risks being a cancellation.
For many DV 2026 winners from these 75 countries, yes.
And just like the family preference applicants, these DV winners, once processing resumes, will also face the stricter public charge vetting criteria.
Absolutely. The goal of the suspension is to rewrite those vetting procedures, and all future immigrant visa applicants, whether family-sponsored or lottery winners, will be subject to the newly imposed, much higher financial screening standards.
The dream of the green card lottery may soon only be realizable by those that can demonstrate substantial existing wealth.
That's the direction this is heading.
Okay, let's turn to where the news is slightly less dire. Non-immigrant visas. We need to clearly define what is not officially affected by this massive immigrant visa halt.
This is a critical distinction. The policy is targeted at permanent residency.
Right.
The sources confirm that this policy does not officially affect work-related non-immigrant visas like the H-series for skilled workers, nor does it affect tourist B or student F visas.
So the official status is that these categories continue to be processed in the usual order.
Correct, because the primary objective preventing public charge is currently legally applied only to those seeking permanent residency, not temporary stays.
But
that is the official line, and it is crucial that applicants understand they can still apply. However, here's where it gets really interesting, and we need to look at the nuance that the sources provide regarding the overall atmosphere and administrative reality.
the reality on the ground.
Exactly. While the processing of non-immigrant visas hasn't officially stopped, the sources emphasize that the overall atmosphere of heightened vetting applies broadly to all travelers from these specific regions.
It's a general tightening of the screws on these 75 countries across the board.
That's a good way to put it. This means that while a student visa applicant from Nigeria or an H-1B worker from Russia is technically allowed to apply, they should expect a practical environment that is much more hostile.
So we're seeing a general tightening of procedures across the board.
Yes, it's part of the broader immigration policy shifts that began in late 2025. Applicants for student, work, or tourist visas from the 75 nations, let's use the example of an F1 student from Egypt or a B2 tourist from Colombia, should expect to experience the impact of more rigorous screening during their application process.
And the practical consequence of this more rigorous screening is often lengthy administrative processing delays, isn't it?
In almost all cases, yes. The consulates, now under pressure to apply this higher level of scrutiny, will lean heavily on administrative processing.
And what does that mean for the applicant?
It often means the applicant is subjected to longer background checks, requests for extensive documentation on their finances, their family ties, their travel history. What might have been a 2-week approval process could now easily stretch to 6 months or a year.
Paralyzing temporary travel plans.
Completely. And we must leap back to the dual context here.
The economic and the security rationales.
Right. The economic fear is driving the immigrant freeze, but the increased scrutiny on temporary visitors is also part of a shift driven by broader security considerations that have been present in other policies. The State Department memorandum may focus on economics for the freeze, but the consulates globally are implementing a broader risk-based approach tied to nationality for all visas.
Let's focus on the F visa category, the student path. The sources suggest that the path for temporary educational purposes remains open, albeit under stricter oversight. Can we confirm that student visas are currently unaffected by the hold?
That is explicitly confirmed. F1 student visas are not subject to the indefinite processing halt scheduled for January 24, 2026.
Okay, because they're not seeking permanent residency at the outset.
Correct. So the public charge suspension doesn't legally apply.
So while the student is excluded from the immediate processing freeze, they must still prove they won't become an immediate burden. And they'll face much tougher questioning and documentary requirements about their intent to return home and their ability to finance their entire education without working illegally.
That's the exact summary of the situation. They are excluded from the freeze, but not from the heightened scrutiny. They need more robust proof of funds, stronger ties to their home country, and possibly an in-depth review of their proposed field of study, particularly if it touches on sensitive technologies or security areas.
A nod to those underlying security concerns.
Exactly. Furthermore, the sources confirm that relatives of students who wish to visit on tourist or other non-immigrant visas may also still have their applications considered.
So those categories are likewise not officially affected.
Not by the immigrant visa suspension, no. The temporary educational pathway remains open, but the bar for entry, even temporarily, has been raised significantly for the entire family unit.
This means that while the front door to permanent immigration is slammed shut for 75 countries, the windows of temporary residency like the F and H visas remain open.
Right.
But they are incredibly difficult to climb through due to administrative pressure and heightened scrutiny.
That perfectly encapsulates the policy's effect. It's a massive regulatory choke point. The administration gets its intended result, a significant reduction in immigration from these nations, without officially banning non-immigrant travel. It uses procedural rigor to deter applications and delay processing.
We've covered the administrative halt, the official economic justification, and the complex geopolitical landscape of the 75 countries. Now we must turn to the future prognosis.
The big question.
This is the question weighing on millions of people globally. Will this restriction end in the future? And will immigration to the United States become available again to applicants from these 75 countries?
The answer to your question is complex, as the situation is both political and legal, but based on the history of similar bans in the U.S., a reasonable prediction can be made.
Oh.
The short answer is yes, immigration will most likely become available again in the future.
Okay, there's some hope.
Some. But this ban could last from several months to several years, and the entry requirements after its lifting will become much stricter.
That forecast, while sobering, provides a necessary framework for those caught in limbo. Let's delve into the detailed breakdown. How and when exactly might this restriction be lifted?
First, we need to understand the terminology the administration chose. This is an indefinite, but pointedly not a permanent ban.
That word choice gives them little flexibility.
It does. The official condition for lifting the ban is clearly stated. The U.S. administration has said that visa issuance will resume when new vetting procedures are implemented.
So the crisis will technically end once the State Department satisfies itself that its new rulebook is sufficiently restrictive.
Precisely. What this means in practice is that as soon as the State Department develops new, stricter questionnaires and rules proving that the immigrant will not become a public charge, the complete freeze will likely be replaced with a complicated new procedure.
A shift from no one to only some.
Exactly. It will shift from a complete refusal for everyone to an admission for only those who can pass very strict financial checks. We are talking about requirements such as providing certificates of high income, proof of significant savings that are liquid and accessible, and potentially mandatory prepaid American health insurance.
That mandatory insurance requirement is a financial killer, given the cost of healthcare in the U.S.
It is a massive financial hurdle, yes. It transforms the family-based system into something far closer to a merit-based system driven by financial capital.
But aside from the administration lifting the ban on its own timetable, we have to consider external pressures. That brings us to the two primary scenarios for lifting the complete suspension sooner.
Right. Scenario A is judicial repeal, and the probability is assessed as medium.
So through the courts.
Through the courts. This mechanism has precedent. In the past, specifically between 2017 and 2020, human rights organizations and immigrant advocacy groups immediately sued against similar immigration decrees, most notably the travel bans.
So the mechanism would involve a federal judge declaring the decree illegal or discriminatory and blocking its implementation, issuing what's called an injunction.
That's how it works. The timeline for this could be relatively short, potentially a few weeks or months for an initial ruling. Advocacy groups would likely argue several points.
Likewise.
First, that the list is arbitrary and capricious, violating the Administrative Procedure Act because the economic criteria are not transparently linked to the 75 countries. Second, they would argue it is discriminatory based on the broad, sweeping nature of the geographic selection.
But the courts don't always rule in favor of the challengers in immigration cases, especially at the highest level.
That is the significant caveat. While lower courts might issue temporary injunctions, the U.S. Supreme Court has recently shown a tendency to defer to the executive branch and the president more often on immigration and national security issues.
So the legal pass is not guaranteed.
Not at all. It would likely face a long, difficult battle through the appeals process, potentially lasting years.
That leaves us with scenario B, change of administration.
Which is labeled as having a high probability, but it is definitively the long-term solution.
This is historically the most reliable, though slowest, path forward.
It is. We have a clear historical example. In 2017, the prior administration imposed a travel ban on citizens from several Muslim-majority countries. That ban was in effect for several years, creating immense disruption.
Right.
But when the succeeding administration came to power in 2021, one of their first official acts on day one in office was to sign an executive order revoking those restrictions.
So the conclusion being that if a different administration with different policy priorities comes to power in the future, for example, in 2029, this current executive order will most likely be among the first administrative actions to be reviewed and potentially overturned.
That's the political reality. A policy implemented via executive order can often be undone via executive order. For those who are frozen now, the political cycle offers the most reliable, though frustratingly slow, timetable for a complete return to prior policy standards.
Regardless of whether the ban is lifted by the courts or by a new administration, your analysis suggests that the underlying character of immigration itself will change. You mentioned that immigration will not disappear, but it will become elitist.
That is the definitive direction. Even if the complete ban is lifted and replaced with the new vetting procedures, the U.S. is clearly moving towards a system where priority is explicitly given to financially independent individuals who are guaranteed not to require public assistance.
So the financial requirements for sponsorship will remain drastically higher than they were prior to January 2026.
I believe so, yes.
Let's summarize what applicants from these 75 countries should realistically expect once the system reopens, even partially.
First, you will have to prove significant savings. We are talking about bank statements proving not just temporary liquidity, but sustained wealth that could cover living expenses for months or years. Second, you will likely need to demonstrate you have arranged for prepaid American health insurance, which can cost tens of thousands of dollars annually.
Removing the fiscal risk from the U.S. system entirely.
Exactly. And finally, sponsors in the U.S., especially those waiting for family reunification, will have to demonstrate significantly higher income than previously required. We are moving from a system of proof of non-reliance to a system of proof of wealth.
Before we conclude, we must address the immediate practical advice for those currently in the queue. They have years invested in this process. Should they cut their losses and withdraw their petitions?
No. The clear advice derived from the sources and historical precedent is do not withdraw petitions.
Do not withdraw.
If you have already filed documents, for example, Form I-130 for family reunification, do not withdraw them. This is crucial because the queue for processing visa numbers, your priority date, is still technically moving slowly within the system.
So you keep your place in line.
You keep your place in line. When the ban is eventually lifted, even if the rules are stricter, you will retain your priority date. Withdrawing now would necessitate refiling entirely later, putting you at the very back of the line, which could add years or even decades to your wait time.
Maintaining your existing petition is vital.
Absolutely vital for any future success.
That is a vital piece of counsel that could save people years of waiting. The takeaway here is that a complete blockade for 75 countries is unlikely to last forever.
Right, because it paralyzes the legal system and profoundly harms U.S. citizens waiting for relatives for family reunification.
The question is simply how long the wait will be and how high the financial bar will be set when the doors are finally cracked open again.
That's the billion-dollar question.
The current freeze is meant to stop potential public charges using criteria based on the country of origin. Consider this. If a judicial challenge were to overturn this ban, would the ruling focus on the economic criteria used or the geographical criteria, the list of 75 specific countries? And which argument do you think is more likely to succeed in the Supreme Court? Something to mull over as you track the rapid changes on the travel.state.gov website.
A very interesting question to ponder.
Thank you for exploring this complicated situation with us. We hope this exploration into the sources helped you understand the nuances of the new policy and its massive impact on the global community.
We encourage everyone affected to stay informed about legal and political developments, and we'll be here to track the next moves from the State Department.
We'll talk to you next time.